Page 23, House Bill 375, a bill to amend the Code of Virginia relating to bad faith assertions of patent infringement penalties. Report from the Committee on Commerce and Labor with a substitute. And, Mr. Speaker, there's a floor substitute as well.
The gentleman from Washington, Mr. O'Quinn.
Mr. Speaker, I move the substitute.
We need to know which of the two substitutes is broader in nature and take that up first. Yeah, which one are you asking me to adopt? The floor substitute or the committee substitute?
The floor substitute.
Yeah.
And
okay.
We reject the committee substitute.
The question before the body is the adoption of the committee substitute. As many as favor that motion will say aye. Those opposed, no? No. Committee substitute rejected. The floor substitute is now before us. As many as favor adoption of the floor substitute will say aye. Aye. Those opposed, no. The floor substitute is agreed to. Gentleman from Washington.
Thank you, Mr. Speaker, members of the House. House Bill 375 addresses the topic of patent trolls, something that many of you may or may not have heard of, but they threaten Virginia businesses every single day by sending them demand letters threatening costly litigation lest they be paid an exorbitant fee. These demand letters are more often than not made in bad faith. Patent trolls will claim a vague patent to something such as offering Wi-Fi in your coffee shop or offering a QR code on a product, things that are in common usage today. And the prevalence of these claims is they are at an all-time high. This has been addressed in a couple of other states, will be addressed more this year, and they are increasingly targeting smaller companies that simply do not have the resources to litigate these claims. It's estimated that each year there are 100,000 demand letters that are received by small businesses all across the country, and what it really amounts to is modern-day extortion. Businesses may or may not have a general counsel, and should they not have a general counsel, they sometimes find it simpler to pony up the $10,000 or $20,000 or $50,000 as opposed to going to court and being hung up for 2 or 3 years in that process. And really, frankly, is a job killer because it takes capital directly out of small businesses and puts it in the hands of extortionists. This is drawn narrowly to deal with those who send demand letters in bad faith, and it establishes a minimum standard for that bad faith, which is laid out in the bill. Now, one thing it is important to note here is that if you are the legitimate patent holder, you are not affected. Moreover, this specifically deals with the act of sending demand letters in bad faith. It does not affect the definition of a patent, how you receive a patent, or how you enforce a patent should you be the legitimate holder of it. This bill is supported by a very broad coalition. At the risk of sounding like the gentleman from Richmond, I will enumerate a few of those. Bankers, retailers, CPAs, Food Marketing Institute, Fairfax and Prince William Chambers, the state chambers. We even had a small issue with the pharmaceutical industry. That's been ironed out. I want to thank them for their hard work on this matter. And I now move that we engross the bill and pass it to its third reading.
Gentleman from Fairfax, Mr. Keam.
Thank you, Mr. Speaker. Speaking to the floor amendment. First of all, I want to thank the delegate for sponsoring this bill and for bringing this issue to our attention. I support this bill, and I'm just trying to figure out exactly what the latest version of the floor amendment is, because I understand there are some exemptions, and unfortunately I couldn't figure out exactly the lines. But my understanding is, and maybe, Mr. Speaker, if I may, can I ask the patron just a quick question?
Will the gentleman yield?
Thank you.
Yes, Mr. Speaker.
Gentleman yields.
I'm sorry I have to do this on the fly, but I don't see the exemption on my version because I think the iPad version doesn't have the latest. But would you mind just telling us what the exemption does on the floor amendment?
Yes, sir, Mr. Speaker. I would answer the gentleman that that's why we took the bill by temporarily. You may need to close your app and reopen it to get that, but it's at the end under the exemptions section, and essentially what it exempts is literally pills that are controlled by the FDA, because there are some pharmaceutical companies that have patents to both the generic and name brand, and it does exclude that.
Thank you, gentlemen. Mr. Speaker, if I may have the floor.
Gentleman has the floor.
Thank you, Mr. Speaker. This is an issue that patent troll and patent reform is an issue that I'm sure most of us in this room don't really have to deal with on a daily basis. And frankly, most businesses, whether you're retail or a technology industry or banks or a pharmaceutical industry, you probably shouldn't have to deal with this in the past. But that's not been the case. Over the last couple of decades, we've seen a tremendous amount of just abusive litigation, demands, and frankly extortion by some bad actors who are targeting deep-pocketed companies to say, hey, you are violating one of our patents, and by the way, I'm not going to tell you which patent you're violating, nor how you're violating it, but we know that you're abusing it. Therefore, if you pay us X dollars, we'll disappear, because we don't want to go all the way to courts. And some defendants who are willing to spend that money and time and go to court end up having to spend a lot of money for an uncertain future. And so at the federal level, there's been an effort over the last decade or so to try and minimize or reduce the amount of litigation. I've had the very honor to and pleasure to have worked on those bills in the past in previous jobs, and so I'm a little familiar with the way this issue has risen at the federal level. So when I first heard about this bill at the state level, I was a little concerned about the question of federal preemption, and many of you might possibly have some concerns, but I want to assure you that having studied this issue a little bit, that what we're trying to do here, and Delegate O'Quinn's bill and the bill that we hope we can support this year, is a very narrowly targeted bill that addresses the state aspect of the abuse. This has nothing to do with federal law or the federal patent issue that the Constitution preempts at the state level. This is about companies in Virginia being targeted by bad actors who are using the ruse of intellectual property and patents specifically to target them for a financial benefit. And that is something that's squarely within our own consumer and business protection laws. Unfortunately, in Virginia, we don't have laws on the books that would cover this type of behavior. And so what this bill does is create a new cause of action for the Attorney General to go after these types of bad actors in the bad faith effort and to do it in a narrow way. Now, I had supported the original bill, which went much farther in terms of creating more causes of action and such. And I understand through the process of negotiations, we've brought it down here. The only piece that gives me a little bit of heartburn here is the exception that the gentleman just addressed, which deals with one particular industry. And I frankly don't have any concerns about carving out any industries if it was in any other context. But in the context of intellectual property and patents in particular, I think we want to be a little bit careful about carving out any exemptions. As I mentioned, there are federal aspects of this issue, there are state aspects of this issue, but there's also an international aspect of intellectual property. And we are, and since 1995, the United States has been a member of the World Trade Organization. And World Trade Organization has a number of provisions within it that allow for member countries to negotiate with each other, including a section called TRIPS, which deals with trade-related intellectual property rights. And under the TRIPS, Article 27, it specifically says that intellectual property must be treated equally, that you cannot discriminate based on locality, region, the types of patents, and the types of industries. And so I'm not sure if this language that we are exempting this particular industry may possibly, pardon the pun, trip over the TRIPS language. But to the extent that that does, I just want to raise that concern that we may be veering a little bit close to that. But with that, I'm willing to accept this bitter pill, if you will, because this is a way for us to move this legislation forward. So I urge the body to support the floor amendment.
Shall the bill be engrossed and passed to its third reading? If any is in favor of that motion will say aye. Those opposed, no. Bill is engrossed and passed to its third reading.